Okay, this is People of the State of Michigan versus Jose Archer, docket number 20-50FH. This is the time set for hearing on the defendant's motion for a PR bond. Mr. Cornish is here for Mr. Archer, who is present, and then Ms. Gallagher for the people. Go ahead, Mr. Cornish.
Good morning, Your Honor. Steve Cornish on behalf of the defendant, hearing via Zoom with consent. Your Honor, as my motion lays out, my client has now been incarcerated for 415 days pending trial. And the defense wants to make very, very clear from the record, we're not accusing the court or the prosecution of anything wrong in that regards to that delay. We understand with COVID, with the health department shutting us down, us not being allowed. And it looks like we're not going to be allowed to do anything until at least April now, based on the most recent orders we've received at our office here. That having been said, the law is very clear in regards to the fact that he is an innocent man until such a time as he has reached that beyond a reasonable doubt during his jury trial to change that presumption of his innocence to guilt. So what we have here is an innocent man who's looking at spending another 60, 90 days in jail at least, putting him up to probably around 500 days incarcerated without ever having been convicted of anything on a reissued case that was dismissed the first time. Now, the prosecution's argument is that, well, that was dismissed because she didn't come to court. And that's because of that additional charge they added, which is this witness interference or intimidation thing. And certainly there is an argument to be made there, but we have yet to see anything that shows that there was some sort of a threat other than her statements, and her being the complaining witness here. What the defense is asking for is what we've asked for multiple times, a speedy trial, which has been ruled to be approximately similar to the 180-day rule, while different. About 6 months seemed to be a reasonable speedy trial. And we're asking simply that it's been more than 180 days. We would ask the court to release my client on a PR bond. I understand the court's indicated previously multiple times that it doesn't feel inclined to do that. If the court isn't willing to do the PR bond, I certainly think that there's other things that could be done. GPS tether for one, reducing the bond to an amount that he could perhaps with family in the area come up with and make. He does have connections to the community. He was working before incarceration and is likely to try and get back into working. He has kids, and unfortunately kids with the complaining witness. But that can all be taken care of through supervision, through friend of the court, through visitation, things of that nature as they allow. I would ask the court to strenuously consider either the PR bond or drastically reduce this $50,000 cash surety bond to something that's feasible for his family to do. Otherwise, it's going to be at least another 90 days at the earliest. We don't even know if that will be a good date. They're talking about the vaccines and stuff, but I'm looking at June or July, and I'm in tier 1 of getting a vaccine. So maybe April, with a lot of hope. I would strenuously ask the court to consider granting the bond motion today.
You want waitress there?
Okay, I'm going to mute the jail. Ms. Gallagher.
Thank you, Your Honor. Your Honor, these charges are serious and violent in nature, and they do involve an intimate partner violence relationship. The defendant has a history that includes assault of crimes and a previous history of domestic violence with this victim and previous victims that would illustrate a propensity for violence against women that he has an intimate partner relationship with. Further, Your Honor, this defendant has a documented history of violating court orders, and on February 28th of 2019, on this original file, before it was reissued, the defendant did plead guilty to violating that court order protecting this victim. This case was reissued, and the victim did testify at the preliminary examination, and it was bound over with the additional witness interference count. Your Honor, no factors or conditions, circumstances have not changed since bond was last addressed, and the people respectfully request bond be left as set, for it is appropriate given the safety to the community and the victim.
All right, thank you. I have ruled on this before, and nothing has changed since the last time that I've ruled on that. I did find previously that there was clear and convincing evidence that Mr. Archer posed a threat to the safety of the community. Not only Ms. Archer, but others as well, based on his past record. He's actually served a stint in the Department of Corrections for a very serious offense, assault with intent to commit armed robbery. And he had, of concern, at least 3 prior, albeit misdemeanor, but assaultive offense convictions. And also of extreme concern in this case is the fact that he violated a no contact order and contacted the victim in this case and actually pled guilty to that violation. And the facts of the case, of course, according to the preliminary exam testimony, are that he essentially broke into Ms. Archer's home and repeatedly assaulted her
Archer, I just talked to him on the phone, they're still gonna see
over
you.
a period of time. And again, for all the reasons that I've previously found, there is clear and convincing evidence that he is a danger to the community. I would also add that I do regret for every single person on my docket that's in custody awaiting trial that we've not been able to do something about that. But of course, as Mr. Cornish noted, it's outside of anyone's control. I have a lot of faith in the April 5th date that we now are working on to open up. It's not really dependent on vaccination, although I hoped that it would be, but it may not be. But we're falling back on the same safety precautions and extensive steps that we took back last summer even to try cases. So with the numbers coming down and all of our extensive safety measures still in place and ready to go, my courtroom's been completely reconfigured, and we have an extensive plan in place to keep everyone safe and healthy. I really think we could go to trial on April 5th. Of course, I'm prioritizing my in-custody people ahead of everyone and everything else. So I feel pretty good about that date. I would also note that although the defendant's been in custody for an inordinately long period of time, longer than I would ever want anyone on my docket to be in custody waiting trial, he wasn't really ready to go to trial until April of last year. And I think that's even mentioned in the defendant's motion because of a change of attorneys and the need for some more investigation. So we haven't even come up on a year. A year is too long for my taste, but you know, in all reality, we haven't even come up on a year where the defendant's been ready to go to trial. So anyway, I just wanted to clarify some of those things, and for all of those reasons, I'm denying the defendant's motion for a personal recognizance bond.